We are back on Morning Line, our final segment this morning with Chris Johnson over with Takis and McGinnis Elder Law, taking several phone calls for folks this morning. And Chris, great at answering the questions. Chris, we've got next on the horn is Lorraine. Good morning, Lorraine. Are you there, Lorraine?
Yes, good morning.
Good morning. How can we help you?
A question. Can one make a power of attorney for the legal and financial part and the medical power of attorney by yourself and get it notarized, or do you need a lawyer? Thank you.
Okay, thank you. A lot of people sometimes say with some of their tax, there are forms you can download on wills and things like this, depending on a state. How much of it is, and again, you're a lawyer, it's what you do, but what do you recommend to people on how to get this done, and what, if you do go, does it cost typically?
Yeah, and so that's a great question, Nick. And Lorraine, the simple answer is this. I'm going to answer your question in two ways. The first is, can you do it yourself? And the answer is yes, absolutely you can. The second part of it is, should you? And obviously as an attorney, I'm going to counsel you that no. And the reason you shouldn't do that is because part of meeting with an attorney is the counsel. You're not just paying for the document. You're not just saying, well, I need a power of attorney, and they're pulling one off the shelf and executing it with you and saying good luck. They're walking you through. There are certain provisions. Do I want gifting authority? Do I not want gifting authority? Do I want it springing? Do I not want it springing? Do I want to put some parameters on it? Some people may say, well, I want a durable general power of attorney, but then when you really pull the thread, what they're looking for is something called a special power of attorney that they want for a one-time transaction. And the second piece of it is just the old adage, you get what you pay for. And so when you download off a free document site, you just don't know what you're getting. Maybe you've stumbled across a well-drafted one. Maybe you've stumbled across one that just isn't worth the paper it's printed on. And you don't want to have a document so critical be in that unknown of, is it going to be any good or not? Part of getting these documents done and having them in place, it isn't just, hey, we're able to use them. It's that peace of mind when you're not using them that they're there. When your head hits the pillow every night, you know, if something happens to me, there is a plan in place, and I have rock solid legal documents there, and I have the team who already knows who they are, knows where the documents are, and can start acting right away. And when they go to act on your behalf because something awful has happened to you, they're not blocked right out of the gate because someone says, hey, this legal document is invalid. So do you have the ability to execute them yourself? Absolutely you do. Can you download a document off the internet? Yes, you can. Would I? I absolutely would not. As far as price, usually powers of attorney are just a couple $100s, and again, it is going to serve you very well in the future. And the counsel that you get is invaluable as you're working with your attorney, why you're doing this, what we're hoping to accomplish. Are there pieces of the puzzle that we're missing? Do we have some blind spots that we haven't thought about, and what things do we need to bring to bear to cover those blind spots? Peace of mind is a critical aspect of this, and you don't want to have false peace of mind.
Okay, and I guess what you take from that is that powers of attorney vary from individual to individual. I mean, you understand the umbrella, what it serves, but she may have a different need or a thought in mind. As you said, there's all these options out there than I might. And so that's where you sit down with an attorney to say, well, I have this situation, whereas she may have a different one. That makes sense, you know, and you know, it's not too expensive to get it done that way. And would you say that same advice applies to a will? I always remember when Tim came on, he said, yeah, I still remember the will. All to ma, you know, that's what someone wrote on a napkin. And it was that simple. And he goes, the truth is, Nick, that could stand up. Not that there wouldn't be some challenge to it, but you know, it can be very, very basic. But the same attitude when it comes to a will?
Same attitude across the spectrum of your legal estate planning. And that's the part that people sometimes miss, where they say, well, here, I'm just coming in here to get a will. I'm just coming here to get a power of attorney. what we're getting is planning. And what we're doing is we're analyzing your situation, and no two people's situations are the same. And so one of the most dangerous things that happens with people is they hear, well, my neighbor did this, or my friend did this, my relative did this, I just want to do that. Not understanding that they did that due to a specific set of circumstances in their life. Now, if your life is a carbon copy of theirs, maybe it'll work, but most likely your life isn't a carbon copy of theirs. And so your planning and your legal needs need to be analyzed, and the documents produced need to be tailor-made to your personal circumstances. And that is vitally important for a plan to work. The most dangerous words I hear often are, well, my neighbor did this, this is what I want to do. And it's like, well, your neighbor could have done that for a host of reasons that are completely inapplicable to you. And so we need to make sure your plan is tailored to you.
You know, we have the contact information for Takis McGinnis at the end of the show, just so folks know. As we kind of wind things up here, it was several months back I did the story, and you may have seen it. We may have even discussed it, but I like bringing it up again when it comes to wills, that a wealthy individual here in town had passed away, and not long before he did, at some point, you know, he adjusted his will here and there, and he ended up leaving $5 million to his border collie. And that just goes, I mean, you can do that, right?
Yeah, there are all sorts of things that you can do. The court will do its best to honor your wishes. They'll obviously set up some type of constructive trust in that point, have someone manage the money. But the court wants to honor, that's your last will and testament. They want to honor your wishes. They want to make sure that what you want done happens. You are allowed to do all sorts of quirky stuff under the law. Yeah. Now, at the same point, you do want to think, am I doing what's in my best interest? And I'd want to meet the attorney that signed off on that. I'm sure there was a rationale for it. But yeah, it never surprises me what shows up in probate court.
Well, yeah, exactly. And you mentioned probate court, by the way, and that's the whole idea of having a will. You know, beyond just specifying where you want your assets to go, is that you can make things a lot easier if you have the will. If there isn't one and there's an estate that needs to be sorted through, then it's a long, drawn-out process in probate. If you have a will, if it goes to probate, then it's pretty straightforward, right?
Yeah, if you have a will and you go to probate, probate is a tool. And so there are people that probate's the right thing for. You take the will there, the court certifies that it's valid, they open your estate, and then things are administered according to your will. It is timely, it is costly, it is cumbersome, and if you can avoid that with prudent trust planning, certainly where that's the right fit, I advise it. It just makes life a lot easier for the family, but sometimes probate is the right call for a myriad of reasons, and for those people, hey, let's get a will done and get your planning done very simply.
Remind us again where the office is. Are you at a home office, or are you at the legal office right now?
No, I'm at the legal office right now. We are open. We moved into our new location last July at 104 Windcrest Way out here in Hendersonville, and we're loving it. We've got plenty of space. It allows us to social distance a whole lot easier, you know, and as this pandemic's coming to an end, this building and this new facility has made a huge difference, made our clientele feel very safe, and allowed us to serve them even better. So we're very happy to be here.
Awesome. Real quick, we've just got a minute and a half. Let's see if Mike has a quick question. Mike, are you there? You want to go ahead with your question?
Yeah, hi. The question is a quick one. Yeah. When do you know when you have to probate a will or not probate a will? Thank you.
Sure. Thank you, Mike. Just about a minute. Can you answer that for him?
Yeah, I'll give you the short version, Mike, and it'll sound like circular logic, but you have to probate the will when there are assets to probate. And so full probate for $50,000 or more. So if all I have in the world is a $100,000 bank account, but I have a beneficiary designation to a relative or friend, that asset goes outside of probate and it's considered a non-probatable asset. But if I didn't do a beneficiary designation, then it needs to go to full full probate. If you're under 50,000, you can do something called a small estate. Whenever you have a question if the will needs to be probated or not, reach out to competent legal counsel and have them advise you. But probate is required for probatable assets. That's the best way to put it. And those are assets that don't have owners after your passing.
Yeah, so that's why you want to specify ownership before you pass, thus a will, correct?
So the will doesn't specify ownership. It's going to specify to whom it goes to once you pass away. The beneficiary designation is basically a contract with a bank saying this account is vested in this individual at my passing.
Gotcha.
And it's a nice tool to avoid probate.
Gotcha. Chris, it's always a pleasure talking to you, my friend.